Have you ever stopped to think about the invisible set of rules that governs almost everything you do? I mean, when you visit a friend's house, walk down the street, or even browse online. Well, that's tort law. And we're about to pull back the curtain on how this powerful legal idea acts as your own personal shield every single day. Okay, I know what you're thinking. This sounds like the setup to a really weird joke, right? But believe it or not, the answer connects some of the most important legal cases that literally define how we're all supposed to treat each other. So stick with me, and we're going to piece this whole puzzle together. All right, let's dive right into our first big topic. Think about it. Anytime you walk into a store, a park, or even a friend's house, the person who's in charge of that property has a certain responsibility to make sure you're safe. This is the heart of what the law calls occupier's liability. Now, you might think this is just common sense, but the law on this used to be a total mess. Seriously, your level of safety and protection actually depended on why you were there. A customer had different rights than a guest, who had different rights than a trespasser. But thankfully, some very smart judges started arguing for a much simpler, more sensible approach. This eventually led us to where we are today, a single common duty of care for basically everyone who's on the property lawfully. And this quote just nails it perfectly. It doesn't matter if you're there to fix the plumbing, deliver the mail, or just have a cup of coffee. If you're there legally, the property owner owes you a duty of reasonable care. Simple, right? Well, it gets a little more complicated when kids are involved. So the law is smart enough to know that kids aren't just tiny adults. They're naturally curious and way less careful. So you have this case, Glasgow Corporation v. Taylor, where a property owner was held responsible because they had these poisonous berries that looked just like delicious cherries. The court called this an allurement, something that would naturally attract a child into danger. But the law is all about balance. In another case, Phipps v. Rochester, a property owner was not liable when a little 5-year-old fell into a big, obvious trench. Why? Because the court said, you know what? The main job of watching a small child belongs to the parents. It's all about what's reasonable to expect from everyone involved. And that duty of care has other limits too. It's not absolute. For instance, an occupier can reasonably expect a professional to know the risks of their own job. There's a famous case where, tragically, 2 chimney sweeps died from carbon monoxide fumes while working on a boiler. The homeowner wasn't held liable. The court's logic was that this specific danger was part of their profession, something a specialist should have been trained to guard against. Okay, so we've talked about your safety on someone else's property. But what about your rights to your own property and to your own personal space? That brings us to our next big idea, the tort of trespass. Now, before we go any further, there's a key legal phrase you need to know: actionable per se. It sounds fancy, but the idea is actually pretty simple. It means that for certain types of wrongs, like trespass, you don't actually have to prove you suffered any harm or financial loss. The act of violating your rights is, in itself, the injury. The intrusion is the harm. And here's a perfect real-world example. A power company went ahead and put up electricity poles on a person's private land without getting permission first. Now, the landowner couldn't show that the poles cost him any money, but the court still said it was trespass. And this is a huge deal because it reinforces a fundamental idea. Your right to control your own property is sacred, and any unauthorized intrusion is a legal wrong, full stop. Okay, so that's trespass to land. But what about trespass to your person? This covers things like assaults, but one of the most interesting areas is what's called false imprisonment. So what does that actually mean? Do you have to be locked in a jail cell? Let's find out. Let's look at 2 cases that show the difference perfectly. In the first one, a guy was blocked from using one specific path across the bridge, but he could have easily just turned around and gone another way. The court said, nope, that's not false imprisonment because his movement wasn't totally restricted. But in the second case, a man was in a room and, unbeknownst to him, guards were placed outside to prevent him from leaving. Even though he didn't know they were there, his freedom was completely taken away. And that was false imprisonment. So what's the big takeaway here? It all comes down to one word: totality. For something to be false imprisonment in the eyes of the law, the restraint on your freedom has to be total. There can't be a reasonable way out. Just being blocked or inconvenienced isn't enough. Your liberty has to be completely and utterly restricted. All right, we've covered physical safety and physical space. But what about something just as valuable, your reputation? Well, tort law protects that too. And this is where we get into the tricky and totally fascinating world of defamation. So what if the harmful words are hidden? This is where the cool legal idea of innuendo comes into play. Check out this case about an amateur golfer. A chocolate company used a drawing of him in one of their ads. Now, on the surface, no big deal, right? But here's the catch. Back then, for an amateur athlete to take money for an endorsement was a huge no-no. So the innuendo, the hidden meaning that people in the know would get, was that he'd sold out and compromised his amateur status. And for that, the company was found liable. Here's a question for you. Do you think you can be on the hook for defamation even if you didn't mean to harm anyone? I mean, if it was a complete accident, you should be fine, right? Well, the law on this might surprise you. The answer is a surprising yes, and this is proven by a wild case called Hulton versus Jones. A newspaper published a funny, completely fictional story about a character they made up named Artemis Jones. The only problem? There was a real lawyer named Artemis Jones, and his friends all thought the unflattering article was about him. Even though the paper had no intention of defaming the real guy, they were still found liable. The lesson here is incredible. In defamation, it's not what you intended to say, it's what a reasonable person thought you were saying. So, let's zoom out and bring this all together. From a dangerous staircase to an unwanted fence post on your land to a careless article in a newspaper, we've seen how tort law is quietly working in the background of our lives. This isn't just some abstract thing for courtrooms. It's the rule book for how we all manage to live together civilly. So what's the common thread through all of this? Whether we're talking about poisonous berries or power poles, it all comes back to this idea of a duty of care that we owe each other. Tort law is the shield that protects our bodies, our property, and our reputations. And at its heart, it's not really about punishment. It's about fairness and constantly asking, what is a reasonable way for people to act? These are real solutions to very real-life problems. So the next time you see a wet floor sign in a supermarket or see a heated argument in an online comments section, you can think about these rules. This legal shield is literally all around you. So the real question is, now that you know what to look for, where are you going to see it in action next?